Hi everyone, today we will do legal dictation exercise number 90. You can get the PDF from description box. So ready? Start. Let us now examine whether a contractor engaged to execute a particular work can file a suit for accounts against the employer in regard to payment for the work done. Such a right is not created or recognized by any statute. The independent contractor is not an agent of the employer, nor is the employer in the position of a trustee with reference to the independent contractor. Can the claim be supported in equity by stating that where the relationship is such that rendition of account is the only relief which will enable the contractor to satisfactorily assert his legal right? A contractor who is engaged to execute a work is expected to maintain his own account. At all events, there is no bar for a contractor to keep an account of the work done, even where the contract between the employer and independent contractor may provide for payment on the basis of measurement to be recorded by the employer. Nothing prevents the contractor from measuring the work done by him and then suing for the value of the work done. The contractor may also demand joint measurement to determine the quantum of the work done. If the employer for some reason does not cooperate or prevent the contractor from taking a physical measurement, the contractor can seek appropriate legal remedy which will enable him to take measurement or to secure the information from the measurement book in the custody of the employer. Therefore, either the fact that the measurement book is maintained by the employer or the fact that the contractor does not possess the exact measurement will not entitle the contractor to file a suit for rendition of accounts against the employer. A careful reading of section 149 shows that it would apply only in respect of the court fee payable at the time of institution of the suit. If the court fee due on the plaintiff when instituted is not paid wholly or partially by the person instituting the suit, the court in its discretion may allow him to pay the court fee or deficient court fee within the period fixed by it. Section 149 has no application where the court fee due on the plaintiff as per the valuation of the suit is fully paid, but subsequently it is found that a larger amount is due to the plaintiff. For example, if the plaintiff values the suit at rupees 2 lakh and the court fee payable is rupees 20,000 and the plaintiff pays a court fee of rupees 10,000 on his request, time for payment of balance of rupees 10,000 can be extended by the court at its discretion under section 149 CPC, but where the claim was rupees 2 lakh and full court fee of rupees 2 lakh was paid at the time of institution of the suit, the question of permitting the plaintiff to pay deficient court fee at that stage does not arise, as no court fee becomes payable at this stage. Thank you. Please subscribe my channel Steno Star.